and asylees. And we will touch base on just the more broad changes that have been going on for adjustment of status as well. So yes, I'm Alexander or Allie because there's like six Alexandras at Murray Osorio. I've been there for about 3 years, and then Michaela, I'll let you introduce yourself.
I'm Michaela. I'm an attorney at Murray Osorio, and I've been here for a little over a year now.
All right. Yep. So adjustment of status for asylees, refugees, as well as Michaela will get into some pointers of what is needed for those actual applications themselves, some interview points, and some recent reflections on what we're seeing right now in like interviews that have happened this week, for example. All right, Michaela.
Okay. Um, so, like we said, we are going to focus on adjustment of status for refugees and asylees. So they're actually governed by two different statutes, and by statutes, that's another word for law. Adjustment for, and when we say adjustment of status, we mean the process of applying to obtain lawful permanent residence, which is also known as applying for a green card. And refugee adjustment of status is governed by INA, which stands for the Immigration and Nationality Act, Section 209A. And then asylee adjustment is governed by a separate subsection of that statute. So that's INA Section 209B, and they have different requirements. All right. So, Ali, I'll let you take this one.
Do you want me to do refugee and do asylee?
Yeah, that's fine.
Okay. Okay. So under the adjustment under the INA, there's a couple of main things that need to be met before you can actually send in the green card application. So one of the main differences that I think a lot of people don't know, the difference between an asylee and a refugee is where you have received your relief. So you get asylum when you're already in the United States. You come here to then ask for it and apply from within the borders of the United States. Or a refugee, you get that status before coming in. So you enter with that protection already. So the determination, first off, is by the Department of Homeland Security that has done the vetting and interview process before you're entering to the United States. And you are admitted under the specific section of the 11457 of the INA. Um, and then once you are admitted into the United States, you have to wait 1 full year of having physical presence in the United States before you can then apply for that adjustment. So something to kind of think of is maybe keeping a record of proof that you've been in the United States. That can be things like pay stubs from your job. It can be, like a lease agreement, but things to show you've been here for, the 365 days. Um, Now there's been a little bit of updates where if you have not applied for adjustment of status at that 1 year mark, um, that you could possibly be returned to the custody of DHS for re-inspection and examination. Um, uh, I feel like I'm missing something, Michaela.
No,
Okay,
so
yeah.
yeah, that's pretty much it. So refugee adjustment is different than asylee adjustment, as you'll see. So you should apply for adjustment within 1 year of entering the United States as a refugee. And if you don't apply for adjustment of status within the 1 year, you can be returned to the custody of the Department of Homeland Security. So in the past, returning to the custody of the Department of Homeland Security had a non-sinister meaning. So applying for adjustment and going for an interview at the USCIS field office meant returning to custody. It means that you're being assessed for whether you're eligible for adjustment, and that was fine. But recent guidance has shown that USCIS and ICE are now interpreting as return to the custody as that can also mean detention, and by detention I mean an arrest and detention by ICE.
Okay, so refugee detention. So this is still a pretty recent update from a policy from February 28th, 2026, called the Detention of Refugees Who Have Failed to Adjust for Lawful Permanent Status. It's kind of right there in the title. So this memo directs ICE to, have the capacity and the authorization to detain refugees who have not completed their green card application or their green card process. Sorry, by completed, I mean at least applied, started the process. And as the memo tries to specify that a reasonable length of time to determine, sorry, the memo says detention can last yes, the detention can last a reasonable length of time. We don't really have any more insight on what that means. That is a very vague and broad term. Is that, a day? Is that a week? We're still kind of in the dark as far as how they're interpreting reasonable amount of time. Um, and during this kind of reinspection process, they can not essentially reopen the case, but they can relook at the origins and the reason for why you're receiving refugee status in the first place to determine is there, the circumstances that brought you to applying for refugee status, are they still present? Is there still the ongoing crisis in your home country, whether that's like a natural disaster, ongoing civil unrest? Is that still present, or is it now more reasonably safe for you to return? And then as of March 23rd of this year, the district court in the Western District of Massachusetts has issued a nationwide stay of their refugee detention policy. Therefore, ICE is currently enjoined from arresting refugees based on that memo. So, little bit of good news in this, but we still have a long way to go.
Okay. So asylee adjustment under INA Section 209B is a little less scary. There's no provision in this statute that allows for that explicitly directs the Department of Homeland Security to return, the applicant into the custody of the Department of Homeland Security for failure to apply within, a certain period of time, which is good news for asylees. Okay, so an individual who applies for an asylee who applies for adjustment, the requirements are essentially that they have to be physically present in the United States for at least 1 year after being granted asylum. They have to continue being eligible for asylum, so they have to still meet the definition of asylee. They cannot be firmly resettled in any foreign country. So that means, you can't move to Germany. And then you have to be admissible. So admissibility is a pretty complicated concept to explain in immigration law, but think about it as you can't violate certain immigration laws, like committing certain, serious crimes. And okay, yeah, we can go to the next slide.
Anyways,
Okay.
so
Um,
when are you, go ahead. It's
no, no,
kind
go
of a
ahead.
continuation, so go for it.
So you have to be present so this is something a question that we get a lot and a lot of people worry about. Applicants have to be present in the United States for 1 year, not when they file an application for adjustment, but when USCIS adjudicates the application for adjustment, and that application is called a Form I-485. So generally at our law firm, we file these applications all the time for 1 year. And Allie can speak to the experience of what happens when USCIS tries to adjudicate a Form I-485 before 1 year, because I personally haven't had that happen to me. But it's USCIS is supposed to just put a pause on your application until you've been in the United States for 1 year.
Mhm. And part of the reasons we feel pretty secure in advising, yeah, if you want asylum, a month ago, we can start the application now, is the adjustment of status application process. It takes a while. Pre this current administration, I would say would take about a year to about a year and a half, and you may or may not have an interview, at USCIS to just go over the green card application, nothing about your asylum application. That is done, that is adjudicated. Prior to this administration, it would take about a year, year and a half for the adjudication process anyway, so you were safely outside of that 1 year mark. Now they are taking even longer. As of last year, this administration announced they were doing a more deeper kind of vetting process for asylum-based green cards. So we are seeing a much longer time period, closer to maybe 2 years, maybe getting to the 2.5. So we're definitely still safely within that outside of that 1 year adjudication time. But as Michaela said, I've come across about 2 or 3 cases where they were denied because it was, you know, 11 months and 2 weeks before the adjudication. And we just turned around, reached out to USCIS saying, hey, here's this protocol that you guys are supposed to follow, that if this somehow happens, you just put a pin in the case and then reopen it when we hit month 12 and then adjudicate. And we were able to reopen both of those cases, and they did finally adjust. So there is a solution. We can get creative.
Okay. So as many of you might have heard, there has been a adjudication pause at USCIS. So since November 2025, the Trump administration has put a freeze in place specifically for nationals from 39 countries. And this has paused a number of USCIS benefit applications, including asylum processing, work permits, green card adjustments, and the citizenship process or naturalization process for the nationals from these 39 countries. So in early 2026, there was a partial resumption for individuals for some countries because the ban was originally larger. I think it was 76 countries, Ali. I can't remember off the top of my head. It was around 70 something countries. But the freeze remains for individuals from 39 countries. Um, so those countries include namely Afghanistan, um, Syria, etc. And so if you are from one of those countries, and you are seeking adjustment, unfortunately, there will be no movement on your adjustment of status application, and we genuinely do not know when that freeze will be lifted.
So just kind of break down. We just kind of went through. So what exactly is still right now paused for? It's gone down from like 75, 76 countries to now 39 countries, but there are two kind of tiers of how they're in effect. So the freeze remains in place for, again, as Michaela said, we have no idea how long, for work permits, green card applications, asylum applications, and citizenship applications. There are still holding interviews, and like the cases are still ongoing. The freeze just applies to the decision. Um, in the same kind of vein, USCIS has ordered the re-review of some of these benefits already granted to some of these nationals. And so I'll just break down the countries for you. So the ban divides into two countries. So 19 have the full ban, and that's Afghanistan, Burma, Chad, Republic of Congo. The list goes on. And then the partial ban is, Angola, Malawi, Nigeria, Senegal, that doesn't have as many of those restrictions.
Okay. So let's talk about the topic of the most recent adjustment of status memo that was released last week. So on May 21st, 2026, USCIS released this policy memo um, interpreting adjustment of status under the Immigration and Nationality Act, Section 245. So remember, when we talked about adjustment of status for asylees and refugees, we I said that adjustment of status for asylees and refugees is governed by INA 209A and INA 209B. INA Section 245 doesn't apply to asylees and refugees. But for those whose adjustment is governed by INA Section 245, so that includes individuals who, are family applicants, are tourists, are on tourist visas, are sponsored by their employers, etc. This memo impacts them. Um, USCIS says that adjustment of status is a matter of discretion and administrative grace, even if the applicant is statutorily or is eligible to apply under the law. Say they've met all the requirements, they're able to apply under the law. USCIS, you know, it's in their discretion whether or not to grant the application. So the impacts of this memo are that remaining in the United States to apply for adjustment of status should only be allowed in extraordinary circumstances. Because as of right now, many people are permitted to stay in the United States while their adjustment of status application processes. But USCIS is now saying, nope, the right to stay in the United States while your adjustment of status application processes is really under the law, not supposed to be happening. It should only be happening in extraordinary circumstances because adjustment of status is an act of discretion and quote unquote administrative grace. Really, applicants should be leaving the United States to consular process. So that's the process of applying for an immigrant visa at the consulate abroad in an applicant's country of origin to obtain lawful permanent residence.
So while this is, turning everything on its head, we are still advising, people who are eligible to apply for adjustment of status here to go for it, to treat things as normal, that this is a policy change, it is not a change in the law. And this week we've had a couple of attorneys go to these exact type of adjustment interviews. And from what they're experiencing is either, one of them, they didn't even ask any of these questions. It was like a totally normal interview. But what they have been asking a few others are things like, why didn't you counsel process? Why didn't you overstay your visa? But from what we've heard again, it's very much with the kind of tone of, I have to ask these questions, but like, let's just going through the motions more so than having a large level of scrutiny. Again, this is a very, very, very small sample size of like 4 cases. And it's still a fresh policy, so it's going to, we'll see how it kind of grows or hopefully shrinks over time. Oops. Okay, so the adjustment of status process, the green card process. Due to increased vetting, we recommend that individuals with any inadmissibility grounds, so that can be lots of things such as criminal history, or like if this one's kind of ridiculous, but we still have to do it, if you're like a mother or a parent or father or a parent, and when you entered maybe without a visa or without authorization, you brought your minor children. There's a waiver that exists for that. That's a whole other thing. But I'm trying to think of other inadmissibility issues, multiple entries. If there was ever any kind of misrepresentation, like perhaps you used a fake work permit at some point. There's a very long list of things that could be applicable. But if for specifically refugees and asylees, there are waivers for those kinds of issues to kind of, you just disclose them and they should be waived, but we are recommending adding additional good moral character evidence. So that's letters from US citizens or legal permanent residents. They can be family, friends, colleagues, members of like your church or spiritual community that can attest to your good moral character and how you are giving a positive influence in the United States and the positive attributes that you contribute. Employment verification, taxes is a really easy one to get done. U.S. citizen minor children, U.S. citizen immediate family members in general, especially if you are like a caretaker, like an elderly relative. And then, yeah, a short affidavit expressing, remorse or understanding of whatever that it admittedly might be, taking responsibility and accountability, and showing how, again, you are contributing positively to the United States. So in addition to kind of an upping the good moral character evidence, the basics that are always going to be necessary. So the form I-485, that is the form for adjustment of status, the green card application. I believe it is 24 pages long. I think the first 13 pages of that is just really biographic stuff like your addresses for the past 5 years, your work history of the past 5 years, parents' names, date of entry, passport number, really basics. The latter half is going to be the security questions like, have you ever committed a crime? Have you ever been arrested? Have you ever sold drugs or trafficked weapons? There's, I think, like 85 questions. But if there's issues, that's something we can definitely help you with as well. Um, Two passport photos, because I will use that photo one for your identification, but second, it will be the one that goes actually on your legal permanent residency card when you receive it. An expired photo ID, so that can be a driver's license, a passport, learner's permit, just some kind of government issued ID to verify your identity. Proof of asylee or refugee status, so that could be your I-94, the order from your judge granting your case, order from the asylum office, or I'm blanking on the form name from State Department. And then again, the form I-693, which is the medical exam. So every single green card applicant, regardless of asylum, family, humanitarian based, employment based, you're going to need a medical exam done by a civil surgeon. And here in the United States, and there is a website on USCIS that can help you find one close to you that if there's a language barrier, you can also search by languages. But the purpose of this medical exam is to, ensure that you don't have any diseases or health-related conditions that could be contagious or affect others for safety and welfare around you. If there are things like that, they will just make you undergo treatment and ensure that you are following that treatment. Um, so the 602 waiver is the one I was kind of talking about earlier. If you did bring your children in with you, or if you did commit a crime or have multiple entries, this is the waiver that you would use along with your adjustment of status. It's actually a very simple waiver because they understand that this is a humanitarian-based case and that, there's sometimes maybe a little bit more complicated history there. Birth certificate. And if there's ways to get copies of that, and if it is in any language other than English, you would need a certified English translation as well. And then finally, if there is any criminal records, a certified disposition from the court. So that means it's, stamped saying this is real from the court. Yeah.
Okay. Um, so interviews. So most adjustment of status interviews are proceeding as normal. I think that, the interviews that I've been to, they've seemed like pretty straightforward. The officer is asking questions that they normally would ask and is not really getting into so many questions. Ali, will you go back to the previous slide? Um, you know,
Sorry.
asking so many questions about somebody's asylum case, or questions regarding, let's say, their family connections, or things that I would think that are related to their security, concerns about their security in the United States, things like that. However, there are definitely cases where, depending on the officer, there is an increased incidence of interviews that are definitely more intense. So I think recommendations are that for asylees, You definitely want to be prepared to briefly discuss why you applied for asylum. So, in one or two sentences, be ready to explain the gist of your asylum claim and why you were granted asylum. What the officer is looking for there is consistency. So they want you to, everything that you say to line up with everything that's in the record. And that's the most important thing with any USCIS interview. You always want to be consistent with everything that has always been filed in your case. So it's that's why it's so critical to carefully prepare for your I-485, to critically prepare your form, your I-485 form. There's so many questions on it. Um, and you want to review your I-480 form so that all your answers are honest and complete and match up with, your asylum application and any other applications you filed with USCIS in the past. So many of the grounds of inadmissibility in immigration law are waived for asylees and refugees. So for asylees specifically, this includes things like, fraud and misrepresentation, alien smuggling, um, unlawful entry or entering without inspection or parole. So that would be like, you entered at the southern border, right? Illegally. When I say misrepresentation, a really common form of misrepresentation is, say you came from Ethiopia and you sat for your visa interview and you were asked whether you had ever been arrested in your past. Say you were arrested and tortured by the police, but you don't want to admit that at your visa interview because you're afraid and you want to be admitted to the United States. It's your only chance to escape Ethiopia. I've had many clients actually in that exact same situation. So you say, I've never been arrested. Um, in your asylum interview, you may tell the officer may ask you, were you honest in your visa interview? And you may say, hey, well, I didn't mention that I was arrested. In that case, that's technically misrepresentation and it's a ground of inadmissibility. Um, if the officer at your adjustment of status interview asks you, um, whether you've ever committed misrepresentation, you have to be honest. You have to be honest about everything that you've done in the past. Another thing that you have to be honest about, and we have to prepare for is any sort of criminal history. So, when you submit your I-485, it's really important to have certified dispositions from the court that show that what happened in your case. And so even if you were just arrested and the case was dismissed, we have to have certified dispositions from the court that show what exactly happened. And another thing that's been coming up, and we'll explain this a little bit more in detail, is this kind of fixation that the administration now has on any possible connections to terrorist or violent groups and any support you may have provided to these groups. So I think specifically Afghans, this really kind of comes up a lot because you may have paid for a passport to the Taliban government, right? Or you may have paid the Taliban because you had to at a border at a checkpoint. And so, you want to work with your attorney to practice these questions and answers. So you're prepared for exactly what will be asked based on, any of these thorny issues in your past. Ali, I'm not sure if there's anything you want to add, especially I know you've done more of
No,
these
you're good. You're
interviews.
good.
Yeah.
So the reason that Michaela is hitting so hard on consistency is key is because the 45 kind of adjudication is going to lay the foundation for when you eventually can apply for citizenship. They're going to go back and reopen at this, and they might, notice that something was at an error. So this is the time to correct those. So when you're preparing your 45 and maybe you notice there is a typo or an error in your asylum application or on some document somewhere that maybe has like your birthday switched, that would be again the time to explain that in the application, which of course attorneys would probably be able to help you more on how to when and where to phrase that. But this is the time to make any corrections and really hit that consistency and disclose everything. Because in 5 years, 4 years, if you're asylee, when you apply for citizenship, they go back. We're like, hey, you said in your interview you were, arrested by, the police in your home country. But this isn't on your visa app. You didn't say it in your green card application. What's going on? Denied. So this is the time to just straighten out everything, and make it as clear as possible on, maybe why it wasn't in a previous application. Because, as Michaela said, you were afraid and you needed to get out of the country. Or I know a lot of answers I've received in that situation is it wasn't a lawful arrest. There was no warrant. There was no judge order. This was not lawful. So there are ways to, articulate the situation because each situation is going to be different. Um, and the other thing I want to touch on is when you're at the adjustment of status interview and they are asking the questions about your asylum or a refugee case, they have a very, very small scope. They only really should say, as Michaela said, one or two sentences. I came here because I was politically involved and I was arrested and tortured by my government. That's it. They are not qualified to understand the merits or adjudicate an asylum case. They should not really go deeper than one or two questions about the basics of your case. I have definitely gotten a little mad when they've done that because it's not appropriate to go really past that bare minimum of how you got here. Okay. So increased vetting and the re-interviews, as we talked about, specifically for those 39 countries we were talking about earlier, but also just all asylum-based and refugee-based adjustment of status cases are being, looked at with higher scrutiny since last year, hence the longer processing time. So what exactly is this additional screening? It's a mixture of additional background checks, international background checks through, Europe, Asia, just making sure you're not popping up in anyone's system anywhere. Um, Diving deeper into your connections back home. So did you have a, uncle that you met once when you were two who maybe went to one Taliban meeting once? They're going to dig and try and find that and bring it out now. They're just really scraping through everything a lot more, especially for those 39 countries. So USCIS is framing it as a temporary pause on finalizing all adjustment of status applications pending this completion of the screening and vetting, pointing to executive orders. But, we are, and like I want to emphasize, we are still seeing cases get approved. That the approvals have not stopped other than, I mean, unless you're from those 39 countries, but like El Salvador, Honduras, I'm trying to think of other countries I've seen recently with approvals, South Africa. Those are, we're still getting approval. So cases are still moving forward. It is just a more kind of elongated process right now.
Okay. So, um, the new vetting process is pretty intense. So there a new operation called Operation Paris, which stands for Post-Admission Refugee Re-verification and Integrity Strengthening, was announced on March 30th. Um, and it's for refugee and asylee re-interviews. So what it includes is social media screening for anti-American views, automated biometric matching with real-time criminal alerts. Allie, I'm not sure what that means. If you can
Oh, so
actually,
I think it's the new biometrics.
yeah, but what does it mean with matching with real-time criminal alerts?
I like I think what my understanding was reading it was cases that are like ongoing. So maybe there was like not currently an arrest in, but like some kind of investigation aspect.
I see.
That's
Okay.
my reading of it.
Okay. Yeah, it's a little silly. And then they will be doing database checks for with the State Department. Um, so green card applications are even more delayed. Um, because USCIS officers now have to resubmit fingerprints through upgraded FBI databases. So this affects new filings and pending cases where FBI data had already been received before April 27th, 2026. Um, so as you can imagine, there is just a lot of, you know, sorry, there's a lot of pauses going on. There's a lot of delays because of all of this new additional vetting that they're doing and quote unquote upgrading that they're doing to, with this additional security checks.
Okay. Oh, yes, the public charge. Michaela, I think you know a little bit more about this one. Do you want to take it and I'll take the
Sure.
next one?
Yeah, happy to do that. Okay, so we wanted to also briefly touch on public charge, which is not really related to exactly the adjustment of status, but so I know a lot of people worry about public charge, but I want to emphasize that there's only two types of assistance that are considered public charge. So the first type is government issued cash for income maintenance. Um, and then long-term institutionalization at the government's expense. Okay, so that would be like having to stay in a mental health facility and the government would be paying for it. But critically, asylees and refugees are exempt from the public charge rule, right? So if you have asylee status, if you have refugee status, when you're filling out the I-485 form, you'll actually check a box um, where you don't have to fill out something called an affidavit of support. You're basically, you just are not even touched by this rule at all. So it's not something that you need to worry about. And accepting public benefits does not affect your applications for adjustment of status or naturalization. So if you need help, you should accept that help. I have asylees, I have asylees come to me and they're afraid to accept food aid, they're afraid to accept help from hospitals. Please, please, please accept help if you need it because this rule does not affect you. I just want you, please, please accept that. Okay, this rule does not affect you. If you need help, accept it. Um, so there has been a recent change in the law under this administration, and it limits what help you're eligible for, but it does not make you a public charge. Okay, it's not going to limit your eligibility for any sort of immigration benefit. So under this big, beautiful bill that came out in July of last year, refugees and asylees are no longer considered eligible for certain public benefits they used to be able to get. So that includes SNAP, which is, food aid, like food stamps, Medicaid, and CHIP. Um, so, which is a health program for children, I believe. So now you have to become a legal permanent resident. So you have to adjust status to be able to get SNAP, Medicaid, or CHIP. However, most immigrants have to be legal permanent residents for 5 years before they're eligible for that program. Once you become a legal permanent resident, you're as a asylee or refugee, you can automatically apply for those programs. You don't need to wait. Okay.
I mean, Michaela, you know way more about that than I do. I know this is a little bit outside of our wheelhouse as attorneys and gets a little bit more into that social work. When in doubt, I always recommend clients to go to the ORR or the Office of Refugee Resettlement. They are the experts in, when you need help, ask for it and what you are eligible for, where to get it, and really help with those resources. So that is an organization that I would definitely reach out to for those whenever I have questions or I recommend clients to go to.
I'm sorry,
Yeah.
Ellie. Our meeting is gonna be again. It's gonna be in 10 minutes.
Okay. I
Yeah.
think
So
we're almost there. Okay. So
Ellie.
I'll just kind of run through this timeline. So
Okay.
there's been a lot of changes, especially in the last 6 months of not only just immigration law in general, but specifically affecting asylees and asylum seekers and refugees at every stage in their process, from getting asylum to finally getting their legal permanent residency. So I just kind of broke it down so we could see just this cascading, you know, changes across the board. And I hope they slow down. But we will, we're rolling with the punches and we're making sure to stay on top of it so we can give you guys the best information.
Okay, so final takeaways. Refugees and asylees are facing increased vetting. So you should be prepared for additional screening. We have not seen these new re-interviews really happening that much yet. We think they're coming. We expect them to come, but USCIS is taking forever to do anything. So, we just have to hold our breath and wait. The application process for, adjustment of status is generally the same, but there's an indefinite pause in application processing for nationalities of 39 countries. And as for public charge, refugees and asylees are exempt from the public charge rule, so accept help if you need it. But new Trump era rules restrict eligibility to certain social welfare programs like Medicaid, CHIP, and SNAP. Okay. So I see we have some questions
Yeah, I'm just
in the
catching up
chat.
on those. Oops, oops. Okay. Oh, Michaela, you've been on top of it.
Um,
Okay. So for those who were granted asylum and have a pending um, I-58 I-485 on asylum, will they be affected by this new? Yes, yes. Any cases that are still pending or still open are going to be affected by these. And then to what degree is going to be based on if you are from one of those 39 countries.
I think he means
Oh,
the newest, the one from May 21, that affects 245
got it.
adjustment. And I think the consensus is no, because that affects 245 adjustment and 209. So asylees cannot consular process,
Mhm.
right? So I've see a couple questions asking, should asylees return to their home country to apply for a green card? No. If you are an asylee or refugee, you cannot return to your home country, right? Because you've been granted protection from your home country. If you ever return to your home country, you risk the US government revoking your asylee or refugee status. And you cannot do something called consular process. You have to stay in the United States to get your green card. So we do not think that the this newest policy memo will affect adjustment of status. However, like Ali was saying, if you are from one of those 39 countries and you apply for adjustment of status, your application will be on pause.
A little background noise there. Okay, there we go. Okay. So I'm kind of going from the bottom here. So let's see. Can pending asylum seekers bring a spouse from their home country? So if your asylum is, yes, if your asylum is still pending, you don't have any eligibility or access to like petition to bring someone here, even if it's like a minor child or your legal spouse. Once you have received asylum, though, and if you are legally married to this person, or this is your, legal or biological or legal stepchild that is under the age of 15, then you can do a petition to bring them and extend your asylee status to them. You have to do that within 2 years of getting asylum, but it can't happen when it's currently pending. However, if your family ends up in the United States somehow, you can add them to your application. So then they would receive the same benefits you would. Oh my gosh, someone just popped up. Um,
Um, I see that somebody asked, is it possible that Afghans who came to the US under SIV and
mm,
granted asylum have their status revoked under Trump, especially if they are men? So it's not easy to revoke someone's asylum status. They will have to, the USCIS would have to re-interview them and then put them in removal proceedings, which would mean sending them to immigration court. They would have to have a trial, etc. I think that that's something that theoretically is possible, but it's not something that I would fear automatically happening.
Right. You're not going to get a letter and it's going to be gone. You're going to get a warning that we're going to terminate. You get a chance to respond. If USCIS terminates, you go to court. You can battle out in court. You can also, if there's other things, you can add other applications. There are many layers to giving you that due process than you just getting a letter saying you got to get on a plane tomorrow. It's a long process. This is one of the, when it is kind of a silver lining that it does take so long. Let's see what else here. Uh, I have a pending J1 waiver application going parallel with asylum. And with AJO, is AJO supposed to be adjustment of status? I'm not sure what AJO is.
I think so.
But the bigger process. So you cannot withdraw an asylum application until you have a green card, not a pending green card, not a pending anything else. You cannot withdraw that until you have a green card physically in your hand. If you withdraw an asylum case before that, you will be put in removal proceedings. You will be scheduled to go to immigration court. So it doesn't matter if you have the J1 waiver, you need that green card before you can withdraw.
I mean, the withdrawing the J1 waiver application because I no longer need it, right? I'm working with the Asylum Walk for that.
So, oh gosh, a J1 waiver.
He was granted asylum, I think.
Oh, okay, okay.
Yeah, he was
Um,
granted asylum and now I think he applied for adjustment of status. So he just want to withdraw, yeah,
The J1.
yeah, the
the
J1.
J1. I actually don't know. J1, we don't do a lot of J1s except because they're confusing. I'm not 100% sure on that one, and our J1 person is logged off for the day, or else I would message them. I'll send them a message and see what I find out. Wait, do you know by chance, Michaela?
To me, it sounds, I'm not qualified to advise on it, but I mean, it sounds like it would be okay, but I wouldn't take my advice just because I'm not an expert in J1s. I don't do them regularly.
Yeah, we just
Um,
got
yeah.
only about 1 minute now. Okay,
Okay.
thank you.
So I think, is there any for those who are granted asylum? So I did answer that question. For those who have granted asylum and have a pending I-45, based on asylum, will they also be affected by the new adjustment of status memo? No. Someone asked about mandamus for several questions about mandamus for green card applications.
Mhm.
So, unfortunately, um, mandamus for green card applications is unlikely to be successful. Federal courts have been ruling that green card applications are within USCIS's discretion. And so they are what is called immune from, or, they're not able to be reviewed by the federal court. So it's something that you can attempt. You can attempt a mandamus lawsuit, but it's unlikely to be successful. Our firm is trying to litigate it, but we're not seeing a lot of success right now.
Yeah, I think you already have answered all the questions. I just want to say thank you everyone for joining us today. Thank you, Ali and Mikhail, for this wonderful presentation as
Of
usual.
course.
Yeah, thank you so much. We really appreciate your time and this wonderful presentation. It was very informative. Thank you
Yeah,
everyone for joining us, and please fill out the survey so that we can improve this kind of presentation in the future. And also tell us any topics that you want to make a presentation